Okay, so let's get started. Piyush, firstly, thank you so much for taking out time on a Sunday morning to give us a masterclass on data privacy and protection. And all the participants, thank you. I hope that you take away a lot of insights from this session. Before I hand it over to Piyush, a little bit of background about him. Piyush and I think we've known each other for close to about 10 years now. He's a very seasoned leader with close to 20 years of experience in risk governance, client management, service delivery, and with a deep specialization in data privacy governance. His his role. Sorry, somebody's saying something? No. Okay. So yeah, I mean his role at Genpact, he's built and led a global data protection program, shaping the strategy, the execution, and board level engagement across industries such as and I think pretty much across all the industries of financial services, IT, ITES, manufacturing, all of those areas. He has hands-on experience in driving risk-based privacy programs, building governance frameworks, and leading initiatives across DSARs and incident management, supplier risk management, and privacy tooling as well. Piyush is certified CIPPE and CIPM, and he blends the strategy with execution and brings a unique ability to make privacy practical and impactful for businesses. So with that intro, Piyush, I'll hand this over to you. And as usual, the ground rules, folks. We'll let Piyush start the session. If you have any questions, please feel to raise a hand and ask the question, or if you want, just put it out on the Teams chat, and we'll kind of consolidate them at an appropriate time and ask those questions. At the end of this session, we'll have question and answer session that we'll moderate. And yeah, then close the session post that. So Piyush, with that, I'll hand this over to you.
Okay, thanks, Arindam. Thanks for that elaborate introduction. So yeah, Arindam and I, we've known each other for about 10 years, worked for about almost 7 or 8 years together. So let's start with this. So what we want to talk about today is concepts around data privacy and compliance. We'll not go into the laws of of privacy because that's a very complicated subject and requires much more deep dive. So I thought I'll put a coffee picture in the background just to sort of make sure that things are lively on a Sunday morning. So yeah, thanks to Arindam to organize this and having me here, and thanks everyone for joining. So as Arindam said, so I work currently with Genpact. We've been with the organization for about 8 years, a little over that. Throughout, been in the information security team, and part of that tenure, I've built out the privacy program for the organization. This was a completely grounds up experience, so it was an immense learning opportunity, and therefore, I can talk about some of these concepts. I'm not a lawyer by education or by practice. Privacy is often confused with being a very legal subject, and that's one of the attempts today is going to be to make sure that we talk about it. We talk about it from an implementation and practice point of view. So I kind of consider myself as more as a practitioner than as a legal expert on privacy. Yeah, so let's move on. So we'll talk about the general data privacy landscape, what privacy really means, why is it important. Some touch upon various governance frameworks and implementation frameworks. That will be important to understand how one can implement privacy in any organization. Can we take a risk-based approach rather than going all org on by using one of the frameworks from the external world? We'll touch upon some key regulations, not go deep into that, and we'll then go one by one into some of the compliance obligations that are there. So privacy. So let's talk about privacy before we dive into the topics that we want to cover today. What exactly is privacy? So a lot of people confuse privacy with hiding everything by saying that I'm not going to share, or if some of my data is obtained by somebody else, and there is a breach of privacy. And fortunately or unfortunately, privacy is not that. At its heart, privacy is about individual autonomy and control. What it really means is that it's about choice, and choice is the underlying concept behind data privacy. It essentially means that any individual whose data we are talking about, they have the option, freedom to choose what they share about themselves or with others, and how that data is actually used by the third party who's obtaining that data. So therefore, this is a fundamental difference between what we consider as hiding data, which one could say falls under the gambit of secrecy, versus data privacy. So data privacy is about choice and freedom. Um, so it's deep rooted in history. I'll spend a minute on this. It actually goes way back to World War II. The horrors of World War II, which fundamentally shifted the understanding of privacy and how what's the importance of choice for individuals. So the Nazi regime, for example, they use census data and church records, information that people would usually provide without a full understanding of its potential use, to identify, profile, and ultimately persecute Jews and other minorities. And therefore, after that, sometime in 1948, privacy was enshrined as a fundamental human right in the Universal Declaration of Human Rights. That sort of established the importance of privacy, and it sort of was the starting point for a lot of these concepts, even around GDPR and all of that. So they all tie back to that period. The other thing is about, so I spoke about secrecy. So secrecy is usually about, something, hiding something very intentionally, usually with the intention of hiding something that has been done wrong or shameful. It could be used in that context. But privacy is about being able to share things, with choice and with being selective about it. So that's the important thing to remember here. The other thing to remember is that privacy is also not exactly the same as data protection. So a lot of us in the security field might think that if you're protecting data, then we are good on privacy, but that's not the case. You could say that data protection or security is a subset of privacy, but privacy is an overarching concept which requires data protection. So you may be protecting personal data, but that doesn't mean that you're abiding by all the concepts of privacy. So that's the other thing. So yeah. So let's move on. So privacy in today's world is gaining a lot of focus with the onset of AI and things around the explosion of silicon, the microchips, and all of that. The NVIDIA's, SMCI, TMCs of the world. There is a high capacity, very powerful chip in every appliance that we are using, every digital, in every digital aspect around us. Therefore, obviously, there's an explosion of data that is being that we are witnessing. And most of this data is not in individual control. So while data is being generated, what is also happening, at least in the last 3 or 4 years that we have seen, is with the advent of all of these AI large language models, there is a huge debate about who owns this data, which is out there. You've seen companies training their AI models on publicly available data without the permission, and there are obviously privacy implications of that. There are copyright implications of that. Therefore, it's really important to make sure that we are abiding by the basic concepts of privacy, even if we are using some of these advanced technologies. Like Eric Schmidt, the erstwhile executive chairman at Google, he said that until 2003, there were about 5 exabytes of information that was created, and all of that information is now being created every 2 or every 1 day. So there's an absolute explosion of information all over the place. Privacy is also important from a breach perspective. We work in large organizations. We come across data which is not just PII, but any kind of confidential data as well. But there have been multiple breaches in the history, and therefore this sort of underpins the importance of making sure that we are protecting and using this personal data with responsibility. So you had Yahoo breach in 2013, which was very popular. The privacy concepts were not even widely adopted at that time. GDPR was not in place, but the basic concept of personal information still existed. Closer home, we've heard about breaches or compromise on Aadhaar data. We had the ICMR breach. Last year, there was a huge one in the US called National Public Data. It's, I think, a background check companies. More than 2.9 billion records were compromised. This year alone, we started hearing about so many different breaches. The latest one being the Salesforce one, which not just impacted Google, but a lot of other companies as well. And then, there are fines as well. So we have seen, multiple organizations being fined. Most of these are, big tech, but beyond that, we've also seen in the past around 2018 and 2019 organizations like British Airlines and you had Move It and then MGM Resorts, for example. All of them underwent some sort of data breach, and there were fines attached to them. The link that I've attached here, the Wikipedia link, that itself lists about more than 100 breaches on the page, and therefore this just this underpins the importance of data privacy and trying to make sure that we are handling the data with responsibility. It's not a question of if, but when. If we are not responsible in handling private data, personal information of individuals, then the consequences can be quite stark. At a minimum, organizations could face financial loss. There could be trust erosion, especially if you are a company that handles a large amount of consumer data. There can be brand damage, and it could also lead to total collapse of the organization. As an example, Equifax back in 2017, just before GDPR was implemented, they underwent a serious breach of personal data, and the damage on their brand reputation and trust from the individual, because they were handling credit scores and credit reports, was quite immense. Then you had the Facebook Cambridge Analytica. It was all over the news. There were movies made out of it. The underlying reason over there was obviously mishandling and inappropriate collection of data, and then using that data to influence elections and so on and so forth. As an example of value decline, the Capital One breach in 2019. The share price dropped about 20% within a couple of weeks, and I think it involved about 6% drop overnight after market hours as soon as that breach was reported. Now, one thing to remember here is that some of these fines and breaches that I've spoken about, they are not purely because of a hack or a ransomware or somebody stealing the data. A lot of these fines and breaches are also because of inappropriate collection of the data and inappropriate use of the data. So one might think that we have the best of the security controls. But if you're not collecting the data in a responsible manner as prescribed by the privacy principles, as in adherence with the local land law of the land, you could be liable for a fine or be considered as breaching the law as far as handling of the private personal data is concerned. So this piece is important to remember. A lot of us confuse, like I said, data security with appropriate controls around handling personal data. That's not about it. And we'll go into details in some of these. I'll take a pause here if there are any questions or if anyone has any reactions or anything. Yeah, and as we go along, just feel free to ask questions, put them in the chat box, and we'll try and cover those.
Yeah, let's move on. I think Kiran just raised a hand. Kiran, why don't you?
Yeah, so my question is, while these breaches are happening and the penalties have been imposed, but with now Digital India Act, Data Privacy Act, and various other acts coming in,
Yeah.
So are there a possibility of multiple penalties, or because who is going to penalize? Because there is also regulators on top of it from the regulated entities. So are we looking at possibility of any multiple penalties imposed from various stakeholders as well?
Yeah, there could be. I mean, see, the scenario in India is still evolving. We just have the law, and then the rules are also not published yet. Then you obviously don't have the data protection authority at all. There are multiple overlaps between various jurisdictions like RBI, SEBI, and then other financial regulators, and so on and so forth. So how it will evolve in India is still a debatable point. But in theory, yes, there can be multiple fines by different regulators. So
And that
that's
too
not
for
a
same incident.
sorry.
I'm saying multiple penalties for same incident.
Yeah, they can be depending on the jurisdiction, right? So, for example, I think this was TikTok a few years ago. UK still being part of Europe. It was the same incident. I think I mentioned it somewhere here. And they got fined twice. Yeah. So, for example, if you see in 2023, they got fined twice, 345 million euros and then 12.7 million pounds for the same incident. This was about some mishandling of data of minors. So it really depends on how the regulators take a view. But from a India perspective, I think things are yet to evolve, and we'll see how that goes.
Got it.
Okay. So let's go into talking about some of these governance frameworks. So starting point, I think, is thinking about how we want to implement privacy within an organization. And I think, this structure gives a good starting point in terms of implementing a governance structure. This is not very specific to privacy, by the way. If you want to implement any kind of security standard also, you probably go through the same aspects. So what is a privacy governance framework? So privacy governance framework is nothing but a set of guidelines, rules, practices, processes which you would adopt to put together a privacy framework for the organization. The important thing to remember here is that the objective of the privacy governance framework that you want to adopt or you want to put together should be not only to ensure compliance with the regulations of the jurisdictions that you are you're part of, but also make sure that you're implementing the best practices on personal data. So these are two very important things to remember. And the other thing to remember is that this is going to be a continuous process. So it's not as if I've implemented privacy in the organization and I can move on. The simple reason being that the underlying subject matter that a privacy framework addresses, which is around personal data and the way it is processed, can continuously keep evolving. If you're a technology heavy company and you keep adopting new technologies, then the way you process that personal data or even the collection of personal data will change drastically, and therefore you need to continuously revisit what you have done with those processes. Regulations keep changing. We didn't have the DPDP Act until 3 years ago, and we were all abiding by the IT Act. But now we have something new. We're probably in some sort of a limbo right now. Regulations will keep evolving. The CCPA underwent a change over just a period of 2 years. GDPR keeps coming up with a lot of clarifications and new rules. So it's a continuous process. But it will always start with the top. So you want to make sure that your leadership takes the accountability, it sets the tone at the top, and makes sure that they state out very clearly and absolutely in black and white that privacy is an important concept and it needs to be implemented all the way to the ground. Who owns privacy? Within the organization, that's very important to address because there is a lot of debate between whether it should be a separate organization within the company, it should be part of security, it should have an overlap, and so on and so forth. We see many times that it is part of the legal team, but that's not a necessity. So if you are in a very heavily governed jurisdiction, for example, Europe, you probably want to make it part of the legal team. But if not, then it can also be a separate organization. Because then it's easy to cut through other teams and make sure things get done and get implemented and move on. But again, the most important thing to remember here is that without clear leadership, privacy efforts can become very fragmented and ineffective. The next is about policies and procedures. This is about how these dictate how personal data is handled within the organization. It will include all of the operational aspects like your the way you collect data, your retention, your deletion, whether you are publishing policies for people, how are you collecting consent if there is a need for doing that, how are you using that data, and so on and so forth. So this is basically the nuts and bolts. Training and awareness is absolutely critical, especially in a jurisdiction like India, because privacy is not a very appreciated concept here. So you want to make sure that you have dedicated efforts towards training and awareness. The employees within the organization who are handling the personal data, they need to be aware of what are the boundaries, what they can do, what they cannot do, and so on and so forth. Risk management is also very important. You can do all of the things that you want to do, which I mentioned on the right-hand side, but there can never be a situation where we have achieved 100% of perfection. Therefore, we want to make sure that we have a risk-based approach too. We'll talk about that in a little bit. And then monitoring and reporting is something that you obviously want to do because you want to measure your success. So in any mature, framework, this is a key thing on monitoring and reporting. And we'll talk about these metrics also a little bit as we move along. Now, one thing that we should consider is where are we starting from? So if we are early in the maturity cycle of this concept, then you may not want to implement anything and everything. So start small and then build on as you go along. There is a question on how to deal with variability in PI definitions across regulations for a global organization. Yeah, so that's a good question. So if you're a global organization and you're seeing that there is some variations in the way PI is considered across jurisdictions, I think the best way to handle this is to take a superset and adopt a common set of principles across your jurisdictions. But having said that, the basic definition of PII will not generally change across the jurisdictions. So things like contact details and addresses, these are the basic ones which will not change. You will also find aspects around things like credit card numbers, being associated with individuals. They may have a slightly higher consideration in some jurisdictions as compared to the others, but then from a security and best practice perspective, you would want to consider it as a PII, and so on and so forth. So that's a safe way to approach.
Kiran,
Piyush, if you can go to the previous slide. So while most of the enterprises are still waiting for the detailed rules to come up, management is still holding it back. Can we start this at least the couple of measures in terms of having at least a framework, a governance framework within the leadership of the organization, and having a policies and procedures, and at least the trainings can be conducted. The rest of the executions could be parked. So at least the organizations are not starting late. At least then the execution becomes the matter of this thing. So that is what I am pushing internally with this approach. So what is your views on that?
Yeah, absolutely. So we'll get into details of how we operationalize this, and you will see there that none of what we talk about is dependent on any regulation. Okay, so there's nothing stopping anyone from going ahead and starting to implement some of these concepts within the organization. You can choose to not go all hog and at least take the most essential pieces, and then when the regulation comes and you can go deep into it and start maturing that part. So just hold on for a couple of slides and we'll get there.
Got it. Sure.
So we spoke about the privacy governance framework. So privacy governance is nothing but like an overall management system for the organization to make sure that the whats and the whys of the privacy are implemented. But when it gets down to actually implementing, we want to have a implementation framework as well. Again, my starting comment here is going to be that it is not necessary to adopt any of these that I've listed here. But as an example, there are quite a few out there. Implementation framework is basically, the house of how you go about doing the implementation at a ground level. While the governance part is more around strategy and, the blueprints, the implementation frameworks will give you the, things that you want to implement at a ground level. You have the NIST framework, which became popular in the last 2 or 3 years. And this is more US oriented, but it talks a lot about, managing privacy risks. Then you have the most popular, I would say, amongst all the standards that are out there, which is the ISO 27701 and not the associated, but again from ISO the 29100. The difference being that 27701 is like a sister certification to 27001, which I think most of us would be familiar with. The 27701 tells you how to go about implementing a privacy management system, just like 27001 talks about ISMS or information security management system. The 219-100 is again overall basic principles kind of a framework. But from an implementation perspective, 27701 is something that you would want to look at. And then you have the the IACPA's GAP principles and privacy management framework. This is very comprehensive. This, I think, has about 10 core principles supported by more than 70 detailed objectives and criteria. But again, this is not a comprehensive list. We in our organization, I think about in 2018 or something, just when GDPR was coming around, we started with something called the NIMITY privacy framework, which then got acquired by a company called TrustArc. So there can be multiple frameworks. The reason so many of these frameworks have come out is that there is no single certifiable framework out there. So none of these is as popular as a 27001, for example. A lot of organizations who deal with global customers, they start off on their security side, they start off with a 27001. But that equivalent doesn't exist in privacy because every jurisdiction, every regulation has a slightly different approach in terms of how they want to look at the effectiveness. Therefore, at least I have not seen something that has become widely acceptable in the privacy world. 27701 is becoming popular, but I think it still has some distance to go. But again, like I said in the beginning, it is not necessary to start off with any of these or adopt any of these. They all could be good starting points to look at what you want to really do. So let's talk about what are the different components of a privacy program. Sorry, I think the font is slightly low, but I'll try and read out. So this is basically what you want to adopt when you're going down the path of implementation. Again, this entire framework that is there encompasses all possible aspects of a privacy program, and they align with the privacy principles. So we'll talk about the privacy principles as well. Privacy principles are nothing but a common set of principles which you will find in every single regulation and every single framework. So it's almost like saying access controls, good access controls, and good change management and those kind of things. So those are the privacy principles. This aligns with that. Its focuses on addressing privacy-related risks, including compliance and ensuring we promote a privacy-oriented culture. The things that we spoke about a little while ago. So let's talk about a few of these. So what does a good privacy program really demand? It demands that we are informing the data, we're informing the individuals about what kind of data are we collecting about them and how we are processing and what are we really doing with the lifecycle of that data. So it starts off with notices. So we've all come across privacy notices. We keep getting emails about, we have updated the privacy notice. This practice has sort of become a check in the box, but in spirit, what it really means is that, we are being very transparent about what data is being collected from the individuals and how we are processing. This becomes all the more important if the interface is directly with individuals outside the organization. But if not, for example, if we are a services-oriented company with B2B kind of a model, or if we are doing a lot of manufacturing-oriented work for other companies, then this becomes more employee-oriented because employees also at the end of the day are individuals. Okay. Now, the other important thing to remember in terms of concepts is what we call data inventory and records of processing and privacy impact assessments. Now, again, these two things are not mandatory to do. So, for example, the DPDPA India bill does not really mandate data inventories across the board. It only mandates data inventories and privacy impact assessments only for the significant fiduciaries. Most of the organizations will not fall under that. However, as a best practice, again, you would want to create these data inventories and perform some privacy impact assessments because those are the starting points to really know your data, to know where the data is within the organization, how it is being collected, where it is being stored, who handles that data, where is it getting passed on to other organizations, are we deleting it in timely manner or not? So that data inventory and the privacy impact assessments are really good starting points to figure out what all do we want to implement within the organization. And to the earlier question, which was being asked, can we, in the absence of a law, implementable law right now in the country, can we start off with something? Then this is the place to start off with. Forget about notices, forget about creating a privacy policy at this stage. If you just start with knowing what your data footprint in terms of PII is, and then creating a data flow out of it, then that's an excellent approach to start off right now. So as an example, if you have an employee being hired, you want to map out what data is being collected right from the interview stage to the employee's exit, and figure out which of these is really critical for doing the process for that employee during the life cycle. So as an example, very simple example, if the HR team is collecting ID documents, one would really want to get into details of which kind of ID documents are being collected, how many of them are being collected. You don't want to collect 10 different types of ID documents, right? And just create an unnecessary data footprint in the organization. Maybe the purpose is being fulfilled by just collecting one, like a PAN card or an Aadhaar card. Similarly, for e-commerce companies, a lot of e-commerce companies want to collect both their phone numbers and email addresses and contact details and physical addresses. Maybe those are not needed unless you have some ulterior motives, which is around data analytics or use that data for sales purposes and sharing with others, etc., etc. If that is the case, then the idea is to disclose that to the individuals and be very transparent about it. Okay, so that's a good starting point. Resourcing is important. You want to create dedicated pool of resources who will look at privacy, even if it is small. The concept of data protection officer or a data privacy officer falls over here. Again, this is not mandatory at this stage. The DPDPA only talks about having an individual who will be responsible for privacy. So it could be anyone. It could be a CEO. It could be a CISO. It could be the chief legal officer, for example. But for significant data fiduciary, they do mandate a appointment of a DPO. So again, it's not a broad-based requirement. Whereas in GDPR, for example, it is a broad-based requirement that any organization which comes under the purview of GDPR needs to have a data protection officer. Awareness, training, and those kind of things, again, oriented towards the employees as well as the privacy team. Because things keep evolving very fast, you want to make sure that your privacy team is also updated. There are certifications out there which make sure that the employees are aware about the latest developments. Consent management, again, this is very specific to the jurisdiction. So, for example, GDPR does not mandate a consent through and through. So there's a lot of misconception that in Europe, we want to process everything because of only if you have taken consent. That's not the case. There are lawful basis of legal basis of processing data. So consent is one of them. Similarly, there are nuances in the DPDPA. But again, if the conclusion after assessing the law and the requirements of the law is that there is a need for a consent, then you need to have a process around that. And then there are others. I'll talk about security. We've spoken about security. I have a slide also around there. Security is not prescriptive under any privacy law. You just need to have good, reasonably strong security practices, and so on and so forth. And then the other things more around governance, metrics, and reporting we've already spoken about. So this, in a nutshell, really gives what is really needed to get started on the privacy front. Like I said, the good starting point is the creation of data inventories and knowing where those data elements are and for what are they being used for. So again, I'll just take a pause for a few seconds and see if there are any questions here. Okay. So all of this can sound very overwhelming, right? Do we really want to appoint a DPO? Do we really want to implement a process for data subject rights? We didn't speak about data subject rights, but just to cover that off, what data subject rights means is any individual who has shared data with you also has the right to exercise some rights. So they can actually come back to you, for example, and say that you please delete all of my data in very simplified terms. Or give me a copy of all of your data. Again, this started off with some of the Western regulations like GDPR and CCPA and all that. But it's also enshrined in the privacy principles. So unless and until you do that data inventory mapping, you wouldn't know where the data is. You wouldn't know where how the data is being used, and therefore you'll not be able to answer questions from a individual about their data. But again, it's not something that one would want to implement right away when they're starting off on the journey. If you want to take a risk-based approach, those three things on the right are the most important. First is identification, which, like I said, where is the data? How is the data being handled? Where is it flowing? Who is access to the data, and those kind of things. Assess that against some basic principles. You could adopt PIA, privacy impact assessment, or a data protection impact assessment. They're slightly used interchangeably, but DPIA is a very GDPR term. But these are just examples of assessing the privacy risk. Okay, so the idea simply being that once you know where your data is, all you want to do is make sure that you are adhering to the privacy principles, or if you want to go deep, adhering to one of the privacy regulations which is applicable to you. So this is just about identifying the risk. As an example, if you're collecting data from individuals and you're not providing them a privacy notice, or you're not displaying on your website, or you're not asking them to give you consent, for example, that's something that can manifest itself as a risk and could lead to a fine if it is not changed later on. Therefore, once you've done this data mapping and inventory of data, you would know that, yeah, this is a gap in my process and I want to fix that. So that identification is the most important. And then obviously you go on to do the mitigation. If you want to go further, you start implementing processes around monitoring and governance. So you can have basic monitoring in place, which can monitor some of your metrics, like, for example, how many incidents did I have around data, personal data? How many individuals' data have I collected in the last 6 months, new individuals, or how much data have I deleted in the last 6 months? Things like that. Some really basic ones. Again, this is slightly higher up in the maturity curve, but something that we should keep on the radar. And from an accountability and demonstration perspective, records of all of the things that you're doing are quite important. Records of processing is another example where you would create some sort of documentation around these processing activities and say that, okay, I've done so many things, starting from the collection, usage, storage, deletion, those kind of things, and formalize that approach. But again, this is not really mandated by the India bill, for example. Records of processing is required for only significant data fiduciaries, not for other organizations. So this is not, again, something that you definitely have to do. Okay, so let's move on to some of the some examples of global regulations. So GDPR is sort of considered the mother regulation on privacy. It's the most comprehensive and the most well thought out, I would say, but it also has a fair share of criticism in the sense that it cripples innovation and is sort of over restrictive. That's fine, but I think it really sets the tone for other regulations. Brazil came up with one called LGPD. Then you had South Africa called POPIA, and so on and so forth. So there are many. India came up with the DPDPA in 2023. So that map really shows you that global privacy regulation landscape. The things are evolving fairly fast. And almost all countries in the world now have some form of privacy regulation. The US, to my mind, is the most complicated one because they don't have one single regulation like a GDPR or DPDPA. They have multiple industry-wide regulations. For example, HIPAA, or the telecom FTC also has something, and so on and so forth. They also have statewide regulations. So California and Colorado, Virginia, Utah, Connecticut, they were amongst the first ones to come up with. But I think now every state has a regulation, and they all differ amongst themselves in some form or the other. So US to me is the most complicated, which is fairly counterintuitive. Looking at the way US is structured, you have all the big tech data companies which are sort of hoarding personal data, and then you keep hearing about these malpractices and breaches. But then the fact of the matter is that the number of laws in the US are the most, and they're fairly complicated. Middle East, I not updated on that, Archie, but I think there was some news about uh, regulations in Qatar, I think, if I remember correctly. But I'm not updated on that one. Okay, so just touching upon the foundational concepts on privacy principles. So while we started off by talking about how do we go about implementing it, um, and we stressed quite a bit on data inventory and mapping out that data flow. But what is the intention around there? So the reason that we want to do is we want to touch upon all of these privacy principles and make sure that we are able to incorporate these into our data processing. Okay, now these are taken from OECD, which is I think the most generic and most overarching set of principles which are out there. If you take any other regulation or framework, you should be able to fit all of that into one of these, or you should be able to make sure that they are covered by all of these 8 principles that are listed here. So OECD privacy principles were originally adopted in 1980. They were updated again in 2013. And they also form the basis of the GDPR and some of the other regulations that are out there. So what do these really talk about? One is, the limitation on collection and purpose, the first and the third boxes. So essentially what it really means in layman terms is that, we will not go out and start collecting anything and everything. Whatever data is collected has to be obtained by lawful and fair means, meaning that, we can't use deceptive practices, we can't force individuals to give data. And it should be with knowledge of the individual. So I'm being very careful in the usage of the words with knowledge of the individuals, because the concept of consent, for example, is not broad-based. Not all of the regulations require a consent, but what all of the regulations do say is that the concept of transparency should be there. So whoever is collecting the data should be able to clearly articulate what data is being collected and why, and so on and so forth. So that's on collection limitation. I also covered about openness, by the way, which is what transparency really means. Purpose limitation is that you define what data you're collecting for is for a specific purpose. So this is a big no-no in every regulation, which is if you collect some data and you think that you own the data, personal data, and then you can use it for some other purposes which you have not informed the individual about or not disclosed earlier, then that's a big no-no. So as an example, let's say you are a e-commerce company where you said that I want to collect your contact details and address for, just as an example, delivery of some products, right? Now you start doing the business, you collect a lot of data, you have data of thousands, 10,000s, million individuals. And now you start using it for analytics, and you start using it to figure out patterns. You start using it to figure out what people order the most. And you start creating those kind of behavioral patterns, for example. So that's a big no-no unless and until you really, told the individual that you're going to use the data for this purpose. And in some jurisdictions, even when you tell the individual that you're going to use this, it may be considered illegal, unless you take a positive consent from the individual and the individual has the freedom to say no. Okay, so GDPR really talks about this proportionality concept. Use limitation comes in the same umbrella. You can't really go beyond what you asked the data for. Security is an element which is there in every framework and every regulation. Again, it is not prescriptive. It doesn't really give you the security controls that need to be implemented. It just says that you have the accountability to protect the data that you're collecting. A lot of the fines that we spoke about earlier were because these security principles were not implemented properly. Uh, Individual participation, this is equivalent to the data subject rights that I spoke about. So the individual has to be party to the data processing that you are doing. They should have the right to know what data, and they should have the right to access that data, challenge the data that you've collected. If the data becomes inaccurate, they should be able to come and tell you that please correct my data, and so on and so forth. So these privacy principles are really giving the onus on the data collector and the processor to make sure that the individual is protected, and the individual feels that they own their own data. And then accountability. So we'll talk about a little bit of accountability, how to demonstrate that. Essentially, just like I just said, the data controller or the person or the company that is collecting and processing the data has the responsibility and accountability to ensure that they are adhering to these principles. So the onus is on that organization. Okay, so this is what the privacy principles are all about. Yeah, and we'll just skim through these. So we spoke about transparency and openness. Once you know where your data is and how it is being processed, you can decide what kind of transparency and openness you want to give to the individuals. At a minimum, notices should be there, consent if needed. You should be able to tell the individuals what rights do they have with respect to their data. And those notices that you give out to the individuals, they should really talk about, the what, why are you, the need for collecting the data, how are you going to use that data. So as an example, GDPR is very, very strict on automated decision making on personal data. Okay, so this again goes back to their profiling and behavioral matching and all of those kind of things. So what they really say is that if any decision that impacts an individual is being taken in a very automated manner based on large data sets, then that is not allowed at all unless and until you have a proper legal basis. And if you really want to do that, then you should be taking consent and giving full spectrum of choices to the individual. How are you sharing the data, your retention practices, and all of that? So this is a good practice to adopt. We spoke about purpose and use limitations. Only collect what is needed and use it only for what it was collected for. Must be done with lawful and fair means, and it must be informed. So this again ties back to transparency and openness. I mentioned about data mapping. Again, this is a very good starting point. I keep harping on that. Go and ask your process owners, people who are doing these processes, to list out the data elements, the personal data elements that they are collecting. Again, it doesn't have to be prescriptive. It can be just top of the mind. Make them sit in a room for an hour and ask them to list down whatever comes to their mind in terms of data being collected. List that down, ask them to define why each of that data elements is needed. In most cases, what you will realize, if there has been no implementation of privacy before, is that out of the 10 elements that they rattle out, 5 are something that they will not be able to put a finger on why they are collecting that data. Okay, so this is a good practice to also implement something called data minimization, where you can reduce your data footprint within the organization. You can use automated tools. So there are a lot of these privacy enhancing tools like the OneTrust and others of the world, which help you document all of this. They have workflows, which will you can implement questionnaires. They'll go out to different teams. They can fill out what data they are collecting, the reasons, and all of that, and then it can come back to the privacy team for analysis and identification of privacy risks. There is also a lot of debate about around what is the difference between data discovery and data mapping. Okay, so data discovery, you'll come across a lot of organizations adopting data discovery under the name of privacy. It's a good practice. So, for example, Microsoft MCAS has some tools around data discovery. There are others also which are focused on privacy. And just discovering what data you have in the environment. They have agent-based systems which will go out to your endpoints, which will go out to your cloud-based systems and collect all sorts of, enumerate all sorts of unstructured and structured data. But the difference between data discovery and data mapping is data discovery is more to figure out the footprint of the data. So you can't really take actionable steps from a data discovery output as far as privacy implementation concepts are considered. What you would need to do is, so for example, if you go and put a data discovery thing on a pool of HR people, it'll throw up different kinds of, it'll throw up resumes, it'll throw up Aadhaar numbers, it'll throw up contact details and all of that. So you really need to categorize them and then tie it back to your, data inventory. So you can't really say that I've done data inventory just because I've done data discovery. So you need to be able to analyze that data discovery output and figure out what categories of personal data are being collected and then take decisions based on that. Okay, so that's something to remember. Yeah, so breach incident and management. So the way I look at this is not something very specific to privacy. So any organization would probably have a process around handling, security incidents. The best way to handle this is to merge security incident and data breach incident processes, because you already have a framework for responding to detecting the incidents and responding to the incidents. So all you need to do is make sure that you educate the incident handling team to be able to identify whether it's a pure play security incident or does it have elements of data as well. Okay, so that's the best way to handle this. And more often than not, what you will see, and like we saw in the cases of breaches and fines also, a lot of the incidents that are out there that organizations encounter do involve personal data at the end of the day. It's about, somebody sending out email with some PII or some, in more serious cases, a hacker getting into the organization and stealing a database of PII and so on and so forth. So there is a lot of overlap between normal security incidents and privacy incidents. So it makes it just more efficient to make sure that the security incident team is also able to handle privacy incidents. So they can implement their own processes for detection and assessment, containment, and eradication. Now, until this point, you would probably have a lot of commonality. Where it differs is notification obligations. What it really means is, again, ties back to the information to individuals. So if there is a incident about leakage or compromise or mishandling of somebody's personal data, some regulations really require the organization to go back and inform the individual about that, as well as the regulator. Okay, so you may not have that case in a security incident scenario, but in the case of a privacy incident scenario, you will have this. So here is a good place to involve your legal team, who can actually analyze the implication, impact, and the seriousness of the incident, and decide if there is a need for an obligation. It's not black and white at all. A lot of organizations choose not to, but who do are on the side of caution, they will go ahead and disclose that as well. And then you can, your recovery and post-incident review is very common and very overlapping with your security incident side also. Third parties, that's another element within the whole privacy framework. Third parties are often a source of breaches because, in this interconnected world, there's a lot of data flowing between different parties. So we don't want to be in a situation where a lot of our personal data is given out for genuine reasons to a vendor, but the vendor does not have good security and data privacy practices. Okay, so your vendor governance team, if there is one, is a good place to also give them the responsibility for making sure that vendors have good privacy practices. So they would be doing due diligence on security. They can take one more step and start doing due diligence on data privacy as well, before these vendors are onboarded, making sure that they have, they are only asking for data which they really need. Again, going back to the basic principles. They are only processing the data based on what you've asked them to process. They are not, really going and selling the data to other parties outside the two of you, and so on and so forth. So essentially making sure that the vendor has strong privacy practices. There is a concept of data processing agreements. This again came out of GDPR. Essentially, what it really says is that the contracts that you're signing with the vendor, they will also have elements of data protection or privacy. So there are prescribed clauses and so on and so forth, which the originating organization is required to include in the contract. And this is often a point of debate and disagreement between the two parties, but this is something that the legal and the contracting team should probably sort it out. And then ongoing monitoring and exit strategy. Ongoing monitoring, you would probably still be doing security audits of your vendors, asking for SOC reports or ISO reports from them. Go one step ahead, identify the most critical vendors from a privacy perspective, and do some audits on them. Exit strategy, if you're offboarding a vendor, make sure that they are deleting the data securely and giving you a sort of a certificate or whatever, to give you confidence that they are not going to keep that data, hold that data forever, as far as PII is concerned. So those are some practical steps on private on vendors. Security, I think we've spoken about that quite a bit. Security, none of the frameworks and regulations is prescriptive, so they will not ask you to implement 3 levels of approvals for access controls. They will not ask you to define password complexity and so on and so forth. What they do really define are the 3 concepts of confidentiality, integrity, and availability, which I think all of us are fairly well aware of. So it's the expectation is that there are reasonably strong controls to protect data. There was a lot of confusion about encryption when GDPR was being implemented, but now I think that debate has died out because in the cloud environment where all data gets stored, I think encryption is on by default, unless somebody is really careless. Privacy by design is a very interesting concept. So if your organization comes up with new products or new processes very often, then privacy by design is something that you can adopt. There are frameworks around privacy by design, but this is again, if you go by first principles and some basic common sense in terms of implementing the privacy principles that we spoke about, all you have to do is in the development of the product, you are embedding privacy, through and throughout. So it's about, if it's a new product, a new website, you make sure that, there is a place for displaying the privacy notice. If there is a need for consent, your structure of the website has adequate places to, give consent by the individuals, and so on and so forth, those kind of things.
Kiran, you want to, sorry, Piyush, just one quick one. Kiran, you have a question?
Yeah, so while the PII is part of the scope, but if the data is pseudonymized, anonymized, or tokenized, can we say that is excluded from the scope of DPDP?
Yeah, that's right. So generally speaking, yes. If our data is fully anonymized, then yes, it doesn't come under the purview of any privacy framework or regulation. But the way you are, anonymizing it is the most important. So you can go deep into the way, into some technical concepts of anonymization. There are things like anonymization and degrees of anonymization and so on and so forth. So the idea simply being that if you have a data set and you anonymize it, there should be no way to de-anonymize that data. Okay, so as a simple example, if you have a column of Aadhaar numbers in a data set, and you think that you're doing anonymization by multiplying that number by 2 and dividing it by 10 or something of that sort, that's not anonymization. Because if that key of multiplying and dividing is compromised and known by others, then it can easily be de-anonymized, right? So that's where this concept of anonymization comes in.
Got it.
There's a question from Kuldeep. How privacy by design has been adopted across organizations during building new applications, especially AI-based? And are there any frameworks or tools or approaches which CIOs can adopt to improve their privacy compliance? Yeah, so like I was saying, so privacy by design, just like we spoke about privacy principles, privacy by design also has a set of principles which can be adopted in the design phases of any product or website. I've not covered those here, but like I was saying, by default, if you just take, you don't necessarily have to go down that route unless you have a very complex enterprise scale, highly integrated system. If it's just about simple products, then you can just adopt the basic principles of transparency, purpose limitation, being able to provide the individuals about information about that data after it has been collected, and so on and so forth. So the reason it is important to embed these at the privacy by design stage is that once a product has been designed, it's very difficult to go back and start implementing those. Then that becomes more of audit findings, and you go and mitigate those audits by making changes into the product, and then so it's very messy. So if you go from stage one and you include these concepts, then it makes life much more easier. Please help with the high-level approach an organization should take if they are just starting with their privacy compliance program. So I spoke about that. The components of a privacy framework. This one. So and actually this one. So if you look at this, the starting point should be the data mapping and identification stages. Just go out and ask people, your teams who are handling personal data, to start enumerating the data that they collect in a spreadsheet to start with, or you can use one of these privacy enhancing tools like OneTrust of the world. That's a really good starting point. If you get a handle of this, then all the other things become very, very easy. And then you can go on to, build upon that by implementing other concepts like notices, consent, retention, and those kind of things. So the most important is to know the data, where the data is within the organization. So, okay, so we spoke about security. Yeah. So we covered off security. Oh yeah. So the last point on security was, like I said, it's not prescriptive, but if you are slightly higher up on the maturity curve in terms of security, then you probably have certifications like 27001. If you're a service provider, to the Western countries, then you would probably need a SOC report, SOC attestation. All of these will help. Okay, because none of this is a mandatory requirement, but all of these will help in the sense that you would be able to demonstrate that you have good security controls and your controls are working at the ground level. So this is about demonstrating accountability and proof of compliance. So again, if you're just starting off on a maturity curve, then none of this is mandatory. But as you move along, as the laws, especially in India, also when they start getting implemented, some of these will become mandatory. So these are all documented stuff or things that can be documented. One is the privacy policies and notices from a transparency perspective. Records of processing, which is nothing but your data inventory and the associated definitions of how you're processing that data. And privacy impact assessments related to that. But if you deep dive in terms of implementing a GDPR or one of these more comprehensive laws, you would have different formats to keep these records. Data sharing agreements we spoke about with vendors. Consent records, if these are needed. Now, the thing about consent is, why is there a record needed? Because GDPR came up with this concept of revocable consent. Okay, so consent doesn't really mean that I've taken the data and then I own the data. Consent in GDPR terms really means that if I've given a consent, I also have the right to revoke that consent. And when I revoke that consent, simply, in layman terms, that organization is bound to stop processing my data and delete that data. Okay, so unless and until you have a record of that consent, you know when that consent was given and what data was collected at that time, you wouldn't have a way of going back and checking and undoing that consent. In other simple terms, when we join an organization and we sign on the policies of the organization, like privacy policy or some other undertaking and those kind of things, those are consents that we are giving the organization, right? They may not be revocable in the true sense, but they are forms of consent. Incident response logs. This is very important. I think this will be very important from India perspective too. You would want to have a trail of how you detected, handled, and contained the incident. How you came to the decisions of not informing or not informing the individuals and the regulator, and so on and so forth. So this one is very important. Training records, again, this is good to have. If things go down south and go wrong and regulator comes knocking on your door, you should be able to demonstrate that you have good practices in terms of training your employees and so on and so forth. And then retention is another thing. Retention is very high and important in the GDPR scheme of things and generally other regulations also. The basic concept here is that you don't want to retain the personal data for beyond beyond the period it is needed for. So, as an example, if a customer leaves, if an individual leaves your service, and you don't need that data, then you should be able to delete that data. That's the basic concept here. Yeah, there's a question in Vijay.
Yeah, hi Piyush.
Right.
Just wanted to check specifically on the retention.
Yeah.
There's a clear conflict between, as per DPDPA, what about the period for which you can retain the data,
Yeah.
as well as the other regulatory compliances like your Companies Act, where, and your other SEBI compliances, RBI
Yes,
compliances,
yes,
where you may
yes.
have to retain the data for 10 years. So how do you take care of, these conflicts?
Yeah, so that's something that has not been answered so far, frankly. I think everyone was expecting this clarity to come in the rules, but I don't think the rules are also specifying that. So we just have to wait and see how it evolves. My understanding is that the jurisdictional retention law will take precedence over the general guideline of the law. That's how GDPR also defines it, by the way. That if there is another overarching law that requires you to retain the data, then you would go ahead and still retain it for that period. But from a general privacy perspective, the idea is that you don't want to retain it for beyond the duration that it is needed for.
Fair enough. Thanks.
Okay. So we spoke about a lot of things. There were a lot of questions around how can we start getting this done. So these are some 7 steps that I thought of. Now, out of the 7, I think the first 5 are the most important. Get a buy-in from your leadership, from your CEOs, CXOs. Make sure that there is one person accountable for implementing privacy. Have a roadmap sort of a thing, and measure yourself against that at a broad level, not in terms of metrics and all. The most important, operationally speaking, is the data discovery and mapping, which we spoke about quite a bit. Once you are able to, and this is a fairly effort-intensive step if there are multiple avenues of data collection for an organization. If it is a simple, if it is a simple service on the web where you're only asking the individuals to give you email address and their name, then it's a fairly straightforward exercise, right? You just know that these are the 2 data elements. Then you go to the next step around figuring out where and how this data is used within the organization and so on and so forth. So this can be fairly effort intensive, but if you get a handle on this, if you do this right, then life becomes really, really easy for everything else. Then you do a basic gap analysis. For this gap analysis, you can adopt as simple as the principles that we have talked about, or you can go deep and use one of the frameworks. But remember, I think the frameworks make life a little more complicated unless the organization is very mature. Start off with the basic principles around purpose limitation, sharing, whether you know your vendors. Is there a way to audit those vendors? Are the vendors' practices strong? Whether I have retention policies or not, and those kind of things. No need to boil the ocean. Prioritize and plan and create a roadmap and go around doing those implementation of the controls. And the training and monitoring and measuring is something that you can build on top of that as you go along. It's not necessary that you have to start off with that. So those are the few things that you can look at. We spoke about privacy enhancing tools. So there are lots and lots of these out there now. You have OneTrust, which is probably one of the most popular. I think Microsoft also came up with something. I can't recall the name, but I think it's part of their E5 license, if I'm not wrong, or separately. The idea here being that there are 2 types of these tools that can be adopted. One is purely these workflow-based tools. Okay, so where they allow you to create questionnaires, customize them, and send it out to your teams to collect the information on personal data. And then there are these discovery and classification kind of tools, which are more oriented towards doing automated discovery and doing classification of the data in the organization. There are very few tools which tie the 2 together. So maybe if your use case requires, you can look at them separately. But my suggestion would be to start off with the workflow tools. Even if not that, some basic templates on Excel will also do for now. There are quite a few out there which can be adopted. These workflow tools also have the capability of doing consent management. So they'll expose APIs where, for example, if you have a website and somebody comes and gives a consent, that gets pushed via API into that platform, and with some timestamps and everything else, it will store and keep a record. Data masking and pseudonymization tools. These are fairly, I would say, for the lack of any other word, hit or a miss. Their effectiveness is only as good as the structured sense of the underlying data. So this is something that should only be looked at when you achieve a really high degree of maturity in these processes. Lastly, measurement. So we spoke about measuring the success of the program. So these are some metrics that I've listed down. So if you do start to adopt PIAs, privacy impact assessments, then that's something that you can track. If your organization is required to fulfill data subject requests, then you should be able to track that also. So that you know that whether you want to scale up your teams, whether you want to refine your own internal processes to make this process more efficient. And by that, what I mean is that in the aftermath of the GDPR in 2018, there were a flood of DSRs that the organizations they were subjected to. So the individuals thought that they had got some sort of a new tool, and then they just went out and started bombarding the organization, especially the consumer-facing ones. It has died down since, but if in the India DPDP bill also has something like this, I think, and if and when they go live, I would expect a lot of individuals to start exercising their rights. So the effectiveness of this will be again dictated by how well you know your data and how well are you able to extract copies of the data and so on and so forth. But what you want to do is track and keep a record of how soon are you able to turn around these requests, how effective are your own internal processes, so that you can build upon those. Number of privacy incidents, if it is going up, obviously there is a problem. If it is tracking down, then your teams are doing good. Your training completion rates, again, similar. If your teams are adopting trainings, your success rates are high, then that's a good thing to monitor. And obviously, if it is not, then that's something to work upon. Vendors, if your data mapping exercise throws up 100 vendors where you're sharing personal data, then your task is really cut out. You want to go out and figure out a way to make sure that vendor contracts are updated, for example, or you have a way to monitor these vendors at a minimum. So you build out steps on that and start tracking to say that every month I'm going to cover 3 vendors, and maybe also categorize them based on risk and say that I'm going to cover off all of my high risk vendors in the next 6 months and things like that. If you are subject to audits on privacy, maybe your clients are coming in and doing audits, or some internal processes for doing audits, and there are findings, then that's another metric to measure. So at a high level, you can start off with these metrics, and as you go along, you can improvise on them. There is no black and white or any prescriptive list on this. And yeah, so this is the last one. So culture is very important because especially in the context of India, because I think the concept of privacy is not very well appreciated here. But again, it has to start from top down. Your management, your CEOs, CXOs have to really start talking the language of privacy and try and embed them in your day-to-day speak. You have to engage your employees through privacy trainings, through job-specific trainings. So if you have customer service agents who have on their screen a lot of PII being exposed to them, then those should be your focus segment, and try and sensitize them towards handling that personal data and the do's and don'ts. Another good approach is creating privacy champions within your teams. So essentially what it means is that you nominate or you designate one middle level person within each team or department who is responsible for everything related to privacy in that team. Okay, so they can do all of the softer aspects around reinforcing concepts, talking about privacy in their team huddles, for example, monitoring of best practices within the team. And if you really want to put them in charge of these data mapping exercise, that's also possible. But the idea being that instead of doing this centrally, you distribute the work within your teams. So it's almost like a hub and spoke model. And also always remember that privacy is going to be a cross-functional collaboration because your teams are handling personal data, and therefore it can never be a centralized approach. So you have to make sure that you have the reach and you're able to reach out to all the teams and embed these concepts within them. It's going to be a continuous learning, and privacy by design and default is something that you can look at if you have a lot of product development or new processes coming in. And with that, we take a pause, and if there are questions, we can take those now. Yes, Gopal.
Yes, Gopal.
Yes, yeah. Thank you for the session. It was quite informative. For a small organization which is actually dealing with customers in Europe, So far, they have not asked us much about these areas, but what are the pitfalls or something which we as an organization need to be aware of? We do a lot of processing in terms of their data, usually the various drawings they share with us, where we convert them into 3D models. So this is what we do on a macro level. So what is that we should be more careful about or aware of, or how to even sensitize employees specifically that these are some of the do's and don'ts. Okay, might be I've given you a very broad question. So
No, that's fine. I think that's an interesting question because you're dealing with European customers and you are in India. But what I find very interesting is that they have not asked you to do much on the privacy front. So my response to your question would be to go and figure out what level of exposure do you as an organization have to personal data. Okay, so and I can only guess that if it's been almost 7 years since GDPR came in, and if it's an European customer and they have not really asked you for much, then your exposure to personal data may be fairly limited or maybe nil to that extent. And when I say exposure, it is not only the kind of data, but also the volume of data and the type of data. Okay, so if you only have, for example, contact details of your customer points of contact, on your customer organization, that's nothing actually. That's really that's really insignificant. But if you are getting exposed to large data sets which involve contact details and addresses and so on and so forth, then then you have to deep dive. And I would say, like I was talking about in that the components slide, the first starting point, or in the risk-based side, the starting point has to be to do that inventorization of the data. So go back to your teams who are actually getting the data and ask them to list down the elements that they are getting exposed to. And then you really have to do a qualitative analysis to see that, is there something which is putting your organization at a very high risk in terms of GDPR, not just in terms of privacy, but GDPR because you have European customers, and then take it from there. So that's one. So that's risk assessment is most essential. The second you asked is on sensitizing. So look, I think as part of your training culture, if you have training culture, I think you have to embed some basic do's and don'ts. And if you're a small organization, I wouldn't expect you to actually hire a consultant to do this. Just put somebody in charge of doing a little bit of research on the internet and come up with some basic training material around privacy. And it will again talk about similar concepts that I spoke about in this slide, but it will go deep dive. It will do a little bit more deep dive with some examples, with some use cases, live use cases, and so on and so forth. You can customize those for the data elements that you have. But again, it will basically be around making sure that that data that your guys are getting exposed to, they don't start sharing it with others. It is stored securely. It's not as if it gets floated around the organization in Excel sheets and all of that. Those kind of things. So it will be just some basic hygiene controls which will be there. But your first question is where you'll have to do a little deep dive, maybe also consult some lawyers to figure out whether there's something that you really need to do to be in compliance with GDPR. And I'll also go one step ahead and say that if you have really good relation with your clients, then you can straight away ask them to tell you what to do to be in compliance with GDPR.
Thank you.
And also, thanks, Piyush. There are a few more questions in the chat. In parallel, let me also share the links to the questions for the attendees. I'm sharing the link, and this would be only active for 30 minutes. You can go through those questions and submit that form, and we can continue this Q&A. There are 2 open questions as well, and please feel free to ask more questions.
Yeah. So I think the first question is from Bharat. He's talking about collection of data within the education field and then sharing it with in higher education institutions like engineering colleges for admissions and program promotion. So I think this is a very gray area again. So the India DPDP law has some very, very strict clauses and rules around collecting and handling of data for children, but those are oriented towards online social media sort of companies. Also, the India DPDP bill doesn't prescribe consent and those kind of things. it goes back to the basic principles of being able to collect and process data based on the need and necessity. Okay, so just in the way that you have described, I think there is a need for you to share this data with engineering colleges. You have to establish that need, by the way. Okay, so I'm just assuming that you have done that, or you think that it is necessary, and therefore you're doing that. So from a collection perspective, I don't think you really need to do that. But as the law gets implemented, you may need to take some steps around information and transparency. And since these are children, you may need to approach or at least tell their guardians or their parents that you would be sharing the data of their children with higher education institutions. So those are some of the steps that you may want to think about. Immediately, I don't think there is anything that is needed to be done. But that step of establishing the necessity is important. So you really need to ask yourselves whether you would be breaking anything in the chain of process if you don't share that data with the engineering college, and if it's really necessary. That's the question that you have to ask, and it's a very subjective question. It's not a objective yes or no answer to that. Can you elaborate on privacy enhancing workflow tools and suggest some good service providers for NBFC segment in India? So see, we have used OneTrust extensively. I think it's one of the best out there. You could look at OneTrust. It's ONETRUST, OneTrust. I think they have started offering services in India with some local partners in terms of in terms of implementation. So that's one to look at. Like I said, I think Microsoft also has one. So if you are already in the Microsoft environment, I'll just check the name. I forgot. I think it's called Priva. Yeah, it's called Priva. PRIVA. So if you're already in the Microsoft ecosystem, that's another good place to start off with. And then there are others. There is a TrustArc, which is not very common, or their presence in India, I think, is not very prominent. And then there is one called security.ai. They are also good. They also have workflows as well as data discovery and classification kind of a thing. So those are the three. I'll type out the name here. You can look at those. Okay. Are there any more questions?
Anyone with any more questions? I see she has already posted the questions for all the participants on the team chat. Yeah, before we conclude, if there's any other question from any of the participants. I guess not. I think we can then vote of thanks to you, Piyush, for taking out time with us and giving us an insightful session.
Awesome. Great.
Thank you.
I hope everyone found it useful. We just skimmed the surface, to be honest, but there's nothing to be scared about. Most important thing is to start somewhere, and then it unravels on its own.
Yeah, I think the way that the simplified way of developing this program, I think that really was insightful. I've made a whole bunch of notes. So yeah, thank you so much. Really appreciate your